Grace and peace, everybody. Happy Friday to you all. Prayerfully, you had a fantastic work week, fantastic day, and I appreciate you. I appreciate you stopping by to hang out with me on today because we got a fun show. We got a fun show. Now, I have to tell you, I have to admit, I have not been keeping up with the Karen Reed debacle, and I'm really new to this, so I'm not true to this. I'm new to this, so you got to be a little bit gracious. I had to do a little bit of research. I do a little bit of digging. Shout out to Miss Mandy and others who've been saying, Jason, you should look into this case because the story is crazy. So if you've been following this, if you've been tapped into the story for some time, yeah, walk with your boy, walk with me because I'm learning a lot and I've learned quite a bit about this. I don't know everything, but I've learned quite a bit. So what we're going to do is kind of do a primer today. We're going to go over a couple of clips that I found pretty beneficial in giving us like a really high 30,000 foot view. And then we're going to go over this most recent motion that was filed today that Karen Reed had filed and it actually was denied. So we'll talk about that as well. But I do want to thank everybody who's already tapped in. I want to thank Courtaholic for stopping through. There she is. Miss Mandy's in the building. Thank you so much. Appreciate you, David. Thank you so much, David. Trailer's been following us for some time, been following us on the YSL trial. I appreciate you tapping in today. John is in the building. Thank you so much. I appreciate you, sir, stopping by. There goes Teresa. There we go. I'm getting caught up. Look, Miss Mandy's already got her hashtag, free Karen Reed. So she wants Karen Reed freed. I'm like, this story is kind of bonkers. It is kind of bonkers. What's going on, Retired? Thank you so much for stopping by tonight. Thank you so much. So as I said earlier, I'm new to this. I'm learning about the Karen Reed story. I had heard about it as like chatter in the background, and I just had not committed to it. I've had other people say, have you been keeping up with this Karen Reed? I said, I don't know what's going on. But I decided to look into it, and they were right. All of it was true. It's crazy. So today what we're going to do, I got two news video clips that kind of summarize it to a pretty good degree. I know it's not perfect. I know it's not going to be perfect because there's probably some other ones out there that y'all probably think are even more perfect than this one. But I appreciate you nonetheless. So we're going to pull these in. We're going to check it out. And then I'm going to go through this motion that was filed again that I think would be really informative because apparently the Karen Reed trial is not finished at all. So we're not... The curtain closed and people started clapping and ovations and whatnot. And they came back for another one. So we're going to talk about it and hopefully get some understanding. So let me make sure I got this right. I think it's going to look good. Let's see. All right. Looks good over here. Let's give it a shot, everybody. Once you hear it in the chat, if you could chat in the chat, if you could please put an emoji for where you're from. Once you can hear. So instead of saying put a one in the chat, let's put an emoji that depicts where you're from. Let's go.
Outside this courthouse in Canton, Massachusetts, supporters swarmed around Karen Reed, charged with murder in January 2022 death of her boyfriend, Boston police officer John O'Keefe. Reed has strenuously denied the allegations.
I did not kill John O'Keefe. I've never harmed a hair on John O'Keefe's head.
Her defense, bare-knuckled and bold, is making national headlines. Her lawyers alleging in court documents that a fellow police officer was involved in O'Keefe's death and colluded with other people in a cover-up.
You're alleging that law enforcement officials in the state committed murder and that they're covering it up. Why would they want to be involved in this?
Because he's dead. I think things went too far. It was late. There was alcohol involved, but they're all family. And there's many of them involved.
After posting bail, Reed has spent much of the past 18 months in and out of court awaiting a trial date.
And me and my family and my attorneys and my team have marshaled every resource to get to the truth. It just feels like no one else wants it.
Prosecutors allege that Reed hit O'Keefe with her car after getting into an argument earlier in the day, leaving him to die in the middle of a snowstorm in January 2022. But Reed says she had no reason to harm her boyfriend.
I would call him the patron saint of Canton. He was just very selfless, frugal, and I think you'd be hard-pressed to find anyone that didn't care for John.
The couple first dated in their 20s and reconnected more than a decade later in the middle of the pandemic.
So how did you meet up again?
He had reached out to me on Facebook. He said, hey, blast from the past, how's things? And when I saw his picture, his profile picture was with several young children. And then it triggered my memory that his sister and his sister's husband had passed away. And he told me, yeah, I have the kids now. I admired that. I thought that was amazing.
Soon, Reed says she became part of the family, often sleeping over at O'Keefe's house and helping take care of the kids.
He would go to work and I would stay with his niece and nephew. All of the breaks that the kids had, we did something.
But their relationship also had its struggles. Reeve says O'Keefe had been relying more on her to take care of the kids and that he criticized some of the decisions she made with them.
We had an argument on New Year's Eve. We were away on vacation and he became incoherently drunk. And I ended up ringing in the new year with his niece and nephew. John didn't come back to our room till after 3 a.m. So that was rough. I felt very much taken advantage of. He apologized profusely for what happened on New Year's Eve. And he said, if you can't get over it, then you need to spend some time at yours. I can't keep apologizing. I don't want to keep rehashing this.
A few weeks later, they were invited to meet up with some friends at the Waterfall Bar in Canton. And there, they ran into Brian Albert, a fellow Boston police officer who Reed says O'Keefe looked up to. Albert had led the city's gang unit before commanding the Fugitive Apprehension Team. It was the elite squad responsible for taking down some of the city's most dangerous criminals and featured in the 2013 TNT show, Boston's Finest.
1 minute we're walking around, everything's fine, and then 1 minute it's not fine.
Both times I met Brian Albert, he seemed like the type of person that you'd be surprised he's out socially because he doesn't seem like he ever wants to be there.
But at the bar, Reed says there was an invitation to continue hanging out at Albert's home.
I said, can we make sure we're welcome here? Nobody extended the invite to me. I didn't hear the invite extended to you.
They drive to the Albert's house. What happens next is disputed.
So I pull at the foot of the driveway. It's snowing. John has no coat on. It's windy. So I drop him off. He goes up the driveway and approaches the side door. And as I see him approach the door, I look down at my phone.
Reed says after about 10 minutes of waiting in her car, she became irritated that O'Keefe still hadn't gotten in touch with her. And she drove back to his home where she continued calling him before, she says, she fell asleep around 1:30 in the morning. She then says she woke up before 5 a.m. He still wasn't home. She then started canvassing the neighborhood.
Just gonna drive around in the 2 square miles that we spent the preceding night.
After 20 minutes of unsuccessful searching, she called John's friend, Carrie Roberts, and Jennifer McCabe, Brian Albert's sister-in-law, who was also at his house the night before. The 3 women together now headed to Albert's home.
How soon was it when you pulled in there that you saw John's body?
Immediately. And what struck me when I saw him was his mouth was open a little bit and his eyes were shut and he had spots of blood in different areas on his face.
O'Keefe was taken to the hospital and pronounced dead. He died from blunt force trauma and hypothermia. And it wasn't long before Reed became the #1 suspect. Authorities say they had noticed a cracked taillight after they seized her car.
I had told both Jen and Carrie that I cracked my taillight. I said, I just hit my car on top of everything, but I didn't look at the damage. And both women said, it's cracked, it's cracked. Calm down, you cracked your taillight. You're okay, let's go look for John.
But according to police statements, Jennifer McCabe told authorities that while they were looking for O'Keefe, Reed stated, could I have hit him? Did I hit him? And when O'Keefe's body was discovered, first responders who arrived on the scene say they overheard Reed make other statements.
The firefighter said that you said, I hit him, I hit him, I hit him.
I said, I hit him. It was preceded by a did and proceeded by a question mark. What I thought could have happened was that did I incapacitate him unwittingly, somehow, and then in his drunkenness, passed out?
When you walked out of the bar, how many drinks had you had?
I had had probably about 4.
The Commonwealth says that you had 9 drinks that night. That's what the prosecution says.
I don't believe they're saying I wasn't in my right mind.
They're saying you were intoxicated. Is it possible that you might have hit him unwittingly in your admittedly very large SUV?
No, not possible.
3 days after O'Keefe was found dead, investigators arrested Reed for manslaughter. She was eventually indicted on second-degree murder. Investigators reported they found fragments of broken glass on the rear bumper on Reed's vehicle, and that a broken cocktail glass was found by what appeared to be patches of blood near O'Keefe's body.
The victim, Mr. O'Keefe, is last observed on surveillance video with a cocktail glass in his right hand. Same arm that's injured, the same type of glass that is then recovered from the bumper of the defendant's car.
In court documents, the prosecution also claims that Reed's blood alcohol level could have been between 0.13 and 0.29%, above the legal limit of 0.08. In addition, they say pieces of Reed's taillight were found on the scene the day O'Keefe's body was discovered. More fragments of that taillight were found the following week, according to Canton police reports, after the snow melted, which revealed more at the scene. But Reed's attorney, Alan Jackson, has a different theory about how those fragments of taillight got there.
Those pieces of taillight were placed there after the fact.
You're saying evidence was planted.
The pieces of taillight were planted after the fact.
What does the defense believe actually happened to John after Karen dropped him off?
I think he walked into the house. I think he was confronted, was likely brought down to the basement. I think that confrontation got physical, and he was beaten. He was beaten to a point of unconsciousness.
Jackson argues that the autopsy photos of O'Keefe support his theory and not the prosecution's claim.
Looks like he's been in a fist fight and he's been beaten. He's got some defensive wound bruises on the backs of his hand. He's got this massive laceration on the back of his head, a big giant gash, about 2.5 inches, exactly lateral, going from left to right. 2 black eyes, cut over his right eye, cut over his nose. This was a cover-up that John was murdered inside that house. His body was placed outside.
But in a statement to ABC News, the prosecution says there was no conspiracy or cover-up. Such claims have been systematically refuted by evidence submitted to Norfolk Superior Court. The prosecution also said that, according to O'Keefe's cell phone GPS records and 11 witness statements, O'Keefe never entered Albert's home, and that a medical examiner found no signs of Mr. O'Keefe being involved in any type of physical altercation or fight.
There was no evidence that Mr. O'Keefe was beaten and left for dead. There was no evidence of any defensive wounds.
ABC News reached out to attorneys for Brian Albert and Jennifer McCabe, but did not hear back by the time of this broadcast. In a previous statement to the Boston Herald, McCabe's attorney said the whole scenario is baseless. Reed is scheduled to appear next in court again in September.
Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights.
All right. So that is one of them. That is a crazy story. The odd thing is, I think I can probably see a lot of this happening. I can kind of see it both ways, but we got another one as well. So hopefully this will give us, this one is relatively newer, so we can kind of get a better gauge on where they've come so far. So let's bring it back in. There we go. Let's bring it back in. Let's go.
Big break in the case of a Boston police officer found dying in the snow during the blizzard. John O'Keefe was found dead outside of a home in Canton over the weekend.
And the big shocker, his girlfriend from Mansfield now charged with manslaughter.
Did I hit him? Did I hit him?
That's what the prosecution alleges Karen Reed told a friend after dropping John O'Keefe off at a home on Fairview Road in Canton, where he was later found in the snow. The courtroom was filled with Boston police officers and the families of both Reed and O'Keefe, who listened as the assistant Norfolk district attorney laid out this timeline. He said the two were going out drinking at a couple of bars on Friday night before deciding to go to that home on Fairview Road. Reed dropped O'Keefe off there early Saturday morning, did a 3-point turn, and left to go home. While home, Reed's lawyer says she tried getting a hold of O'Keefe.
At 4:30 in the morning, my client is placing multiple calls to the victim in this case, to her boyfriend, wondering where he is, why he hasn't come home.
When she couldn't get in touch, she went back to Fairview Road to see if he was there.
At the time, it was snowing heavily, creating poor visibility.
O'Keefe was found around 6 Saturday morning and later pronounced dead at a hospital.
She discovered the victim in the morning. She observed him lying face up, snow on his legs, eyes swollen and blood coming from his nose and mouth.
Prosecutors say red pieces of plastic that matched the missing pieces from the broken taillight on Reed's car were also found at the scene, while the defense argued manslaughter charges are not justified.
There was no criminal intent. This was not some random stranger. This was my client's boyfriend, somebody with whom she was in love.
We were happy, having fun, laughing, just very normal.
Her attorneys argued that evidence being withheld from them will show that the people inside the home are responsible.
Instead of finally investigating the people who had a motive to kill John O'Keefe, who beat him and left him to die in the cold, in a blizzard, the prosecution has chosen instead to dig their heels in. This will not end well for them.
The attorneys have filed motions to get the phone records of homeowner Brian Albert and his sister-in-law, Jennifer McCabe.
Why did Jennifer McCabe Google search how long to die in cold at 2:27 in the morning, 3.5 hours before she would have any reason to believe that John O'Keefe was dying in the cold in front of Brian Albert's house?
The defense argues Albert, who has a history of fighting, attacked O'Keefe along with his 90-pound German Shepherd. The Commonwealth argues witnesses, forensics, and every piece of evidence to this point prove Reed hit O'Keefe with her car.
I'm just a little confused as far as are they in the conspiracy, or are these people sort of let out of the conspiracy because they say something that doesn't further that conspiracy? If they're all in the house, and Mr. O'Keefe comes in the house and gets attacked by a dog and then gets dragged out to the bottom of the lawn and left there for dead, then why do they all testify that no one came into the house?
What Reed's lawyers were claiming in court today is that there is corruption in this case that might include Judge Canoni. Alan Jackson, Reed's attorney, pulled out a text message that he says Boston Police Detective Sean McCabe sent to a reporter claiming that McCabe had ties to the judge. Reed's defense requested the judge to step down. She denied that motion and any ties to anyone in this case.
I've never interacted with him, and I certainly never have socialized with him.
If you look behind me, you can actually see the barricades set up right now surrounding the courthouse. It's all because of the protests that we've seen in the weeks leading up to this trial. Reed is accused of backing her SUV into her boyfriend, Boston police officer John O'Keefe, and leaving him to die in a 2022 snowstorm. Reed pleaded not guilty to the second-degree murder charge. Her attorneys claim she's being framed as part of a cover-up. The case has drawn a lot of attention, especially from supporters of Reed. That's why state prosecutors have put restrictions in place like that buffer zone that I mentioned. Some argue it's against their First Amendment rights.
Commonwealth is calling it a buffer zone, but they might as well call it a restraining order against the citizens of Massachusetts.
I think she's very unjustly been treated by the state of Massachusetts.
Karen Reed could be any one of us. Thank God she has the money and the means to fight this. But if it was us, one of everyday person, we'd be in jail by now, and you wouldn't even know about this.
What has this process been like for your family?
It's been hell. It's been 26, 27 months of hell.
She said, I hit him. She repeated it. There was a woman standing across from her who I believe at that point said, you're hysterical, you need to calm down.
Just something like, he's dead.
All I recall her saying was, is he alive?
Cross-examination of firefighter Flamati was contentious, as the defense asked him where he was in a video, why his claims weren't in a report, and what he said at the hospital.
You directly told the doctors and nurses that there was a question about whether or not he was hit by a vehicle, right?
Yes.
Have you ever said that in any context, either to the police or in a grand jury before today?
I don't recall.
Boston police officer John O'Keefe's family emotional in court today as the 911 call from the morning he died was played.
How many pieces of taillight did you find on or around that property?
That morning, none.
Reed's attorneys who allege a cover-up also questioning why inside the home wasn't searched thoroughly that morning.
Nobody put John O'Keefe anywhere but where he was found.
The defendant kissed me.
And how did you kiss me?
Not like a friend.
ATF agent Brian Higgins, who had an office at the Canton police station, taking the stand in the Karen Reed murder trial.
Defendant responded, you're hot. I responded, are you serious or messing with me? Defendant responded, no, I'm serious.
Prosecutors showing pages of flirty texts between the two. The same month, Reed's boyfriend, John O'Keefe, was found dead at 34 Fairview Road in Canton.
I'm proud of these text messages. It is what it is. I take responsibility for them. But, John was a friend at the same time. And if they were at the end of the relationship, they were at the end of their relationship. But I wasn't going to have somebody utilize me.
On cross-examination, Reed's attorney pointing out she didn't answer Higgins' text at the bar hours before O'Keefe died.
Well, why are you ignoring me?
It's not correct.
Well, I might chop liver. So where's your phone?
I do not have that phone anymore.
You destroyed that phone, haven't you?
No, I threw the phone away.
Well, that's destroying the phone, isn't it?
I had every right to do that.
I'm not sure if it's in this document, but I can tell you today with 100% clarity, she said, I hit him, I hit him, I hit him.
Wow. All right. So this Karen Reed story is crazy, man. This is bananas. Shout out to all of the subscribers that have told me that I need to get up on this and talk about this. Thank you so much, Ms. Mandy. Ms. Mandy's been saying, Jason, you need to talk about this case. So I appreciate it because, yeah, this case is bonkers. I did not expect it to be that wild and so many ups and downs. Kind of, very akin to our favorite 3-letter trial here in Fulton County for sure. Let me make sure I got this next one ready because we're going to go over the motion that's pertaining to this, and we'll go over that in a second. But I do want to thank, who do we have here? We got the Black Bar, Voices of Justice, with a very gracious $2. Yeah, I promise I can read. $20 super chat. Thank you so much. What do they say? The Black Law Students support you, man. Check us out, streaming everywhere. And I appreciate you bringing it up because I want to talk about that. So you all know Black Law Student, been a foundational supporter of this channel and has been super duper helpful with my understanding of the criminal justice system and so forth. Well, Black Law Student is actually starting a podcast. And I want to take a second to kind of give you a little taste, if you will, a little snippet, a little sample of what they're doing over there, because they're going to be doing some great things. They're going to be looking at highlighting and focusing on justice and in the criminal justice system. So like, of course, this type of story like this, but they're going to be interviewing people that are surrounding these topics. And I talked to them today, and some of the people they're looking to interview are going to be completely blow your mind. So this is, you definitely want to get on the ground floor with them. So real quick, again, thank you so much to the Black Bar. Let me give you this episode teaser real quick. Let's hear what they got to say. You know what?
This podcast of confusing legal jargon. The Black Bar Voices of Justice podcast is here to change the game. Two sharp Black law students break down complex cases and policies, showing how the law shapes our lives. From civil rights to criminal justice, they offer fresh perspectives and real-world examples. Whether you're a legal eagle or just curious, this podcast is your ticket to understanding the power of the law. Get ready for a legal revolution. Are you ready to get woke?
How long have you been practicing?
Almost 6 weeks.
You just can't ask for speculation. That's what you're asking for.
That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you do something like that.
It is a lie. It is a lie.
Under what law and fact can you do that? Okay, but
tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this. You got 5 minutes.
How would we object to something we didn't know existed until it was over?
Remember the court's admonitions, ladies and gentlemen.
All right. So that is the new Black Bar Voices of Justice podcast, as well as their channel. And their channel, of course, the moderators can drop it in the chat. I would love for you to go check out what they're doing. Let me drop it as well. I got it right here in front of me. Why don't I just do that? Let me drop it as well. I would love for you to check them out. And it is going to be a podcast, so they won't be showing their handsome faces, but they got some fun stuff they're going to be doing, especially if you're interested in how law is placated or how laws played out in many different places. They have some, their show is going to be really well done. And they have an excellent team over there that really seem to have a grasp of the podcasting space and the communicating space, as well as the law. So hopefully you'll go check them out. Tell them Dear Woke Christian sent you. I think you'll enjoy it. So thank y'all so much for that. Thank you very much again to the Black Bar for the very gracious $20 super chat. I appreciate you, and I thank you for helping us out with that. Thank you. Now, let us get back to what we got on the docket today. And what we have now, Carrie recently filed a motion file. Oh, no problem. Thank you very much. Thank you. Black Bar, we appreciate you. Thank you so much for that. Now, Carrie recently filed a motion. Thought it was going to be a slam dunk. This case is just a little bit that I've seen. It definitely is confusing. It definitely seems to be hanging on and hinged upon a lot of weirdness. Again, there was some stuff even in the articles that I've read in the video I just saw a moment ago. And like, that doesn't make any sense. So it just seems like there's doesn't make a lot of sense going on in this story, but hopefully, prayerfully, some good common sense will come out of it. So let's go ahead and talk about it. Recently, she was found guilty. We know that part. And there was a lot of kerfuffle around that. So of course, being found guilty, they filed for appeal. And so here we go. This is the Commonwealth's opposition to defendants' post-trial motion to dismiss the case. Here we go. Let's have some fun. Now comes the Commonwealth in opposition to the defendant's post-trial motion to dismiss her indictments for second-degree murder and leaving the scene after causing death, as the defendant's motion is premised upon hearsay, conjecture, and legally inappropriate reliance on substance of jury deliberations. Further, contrary to the defendant's claims, throughout jury deliberations, the defendant was given a full opportunity to be heard. The jury's communications to the court explicitly indicated an impasse on all charges, and the court carefully considered alternatives before declaring a mistrial. The defendant's unsubstantiated but sensational post-trial claim that the jury reached a unanimous decision to acquit lacks any merit or legal foundation. All right, so we've been reading these legal documents. We've been trying to get, I think I said she was found guilty and it was a mistrial. Please forgive me. I did say that. Please forgive me. I told you, I'm new to this. I told you. So we've been reading these for a while, and this is kind of interesting just to see some of the formatting even of how this, like this right here, you can tell this was actually stamped by the clerk, whereas like in Fulton County, there's like a computer generated stamp on it. So it's all electronic e-file versus this looks like it probably was a physical piece of paper that the clerk stamped and they scanned back in, which is just, just something small that I noticed. Let us continue. On June 9th, 2022, the defendant was indicted by Norfolk grand jury for second-degree murder in violation of the, I'm trying to think what the GL might be. Okay, basically violation of manslaughter while operating under the influence in violation and leaving the scene of a personal injury death in violation. On April 17th, 2024, a 10-week jury trial commenced. Beverly Canoni, and I guess that is the judge. The jury began deliberation on June 25th, 2024. In addition to the 3 indictments, the jury was instructed to consider 2 lesser included offenses of manslaughter while operating under the influence, involuntary manslaughter in violation, and 2 motor vehicle homicide, OUI, liquor and negligence in violation to this law as well. Now, this is the part I'm wondering about. And again, I'm a pre-K law student. I don't know a thing. There were some things that were mentioned in the 2 videos that we watched that made my little spidey senses go off. One, they didn't interview, they didn't inspect, and they didn't search the house that he was dropped off at. That's kind of odd. Next, did anybody else hear the type of turn that they said Karen Reed did? They mentioned it in the very first video after she dropped her boyfriend off at the house, the type of turn that she did. She did a 3-point turn, and they made clear to say that. Why did they say a 3-point turn? Because looking at the video and the pictures, the driveway wasn't that narrow that you would need to do a 3-point turn. So why was it that she needed to do that? It's kind of weird. And then the very, very last thing is, in order to break your taillight, you got to be moving a little bit fast. Not saying that it couldn't happen, but to break your taillight, and it sounded like shatter the taillight into multiple pieces all over the place. That just seemed really odd. And that's 3 things I picked up out of the videos that we watched. Like, something doesn't seem right. Something just doesn't pick up. Oh, and then also they found pieces of the taillight weeks after the snow melted. I can't get with that. So those are just some things that kind of stood out. And I'm like, seems weird. Like something isn't right. Whether she hit him intentionally, whether she hit him on accident, I don't know. Whether she was drunk, I don't know. But some of the things that happened and all those bruises the man allegedly had, but the prosecution said he had none. Yeah, I can see why a lot of people were really interested and engaged and tapped into this trial, because there's just a lot of strange things that happened. But let me continue. The defendant's motion states that the court's decision to declare mistrial was sudden, brief, and unexpected, neither preceded nor accompanied by a decision with counsel. Yet the defendant's motion and supporting affidavits of counsel inexplicably omit the full opportunity that the defendant was given to be heard, and the defendant's counsel, or rather consent to the mistrial. Beginning on Friday, June 28th, 2024, approximately 12:15 p.m., the jury sent a note saying, "I am writing to inform you on belief of the jury that despite an exhaustive review of the evidence and our deliberate intent, or rather consideration of all disputed evidence, we have been unable to reach a unanimous verdict. At the time, the court requested argument from the Commonwealth and the defendant as to whether the jury had engaged in due and thorough deliberations according to the law. The Commonwealth responded to the jury that the jury had not had sufficient time to deliberate and requested that the jury be instructed to continue their deliberations. On the contrary, Attorney Yannetti argued, "We believe that there has been sufficient time," and advocated for the jury to be declared deadlocked and provided a Tui Rodriguez instruction. Attorney Yannetti stated that the word exhaustive is the word that I think is operative here. They're communicating to the court that they've exhausted all manner of compromise, all manner of persuasion, and they are at an impasse. You know this is the case when the jury has the legal instructions. They've only really asked one question, which was to try to get a report they were not allowed to get. And I think the message has been received that the evidence is closed and they won't be getting anything more. They've been working essentially nonstop over the last 3-4 days. We're approaching a weekend. They didn't come back with a 3 o'clock, 4 o'clock. They're at 12 o'clock and they have nowhere to turn. So our position is the jury should read the Tui Rodriguez model instructions and go from there. I kind of wonder what is Tui Rodriguez instructions? Oh, okay. Here it is. Tui Commonwealth versus Tui instruction is for situations where after due deliberation, the jury has expressed that they are at an impasse. Okay. So there's the word right there, impasse is where they got it from. The Tui Rodriguez instruction has a certain sting to it. And a Tui Rodriguez instruction should not be employed prematurely or indiscriminately. The court ruled that given the length of the trial, number of exhibits, and the complex issues in the case, there had not been due and thorough deliberations, and instructed the jury to continue deliberating. I have never been on a jury. I can only imagine what it's like when you really feel like, look, we're going to end up starting to fight. We're going to end up starting to throw hands on this thing if we don't get out of here, because I'm getting tired of you and you getting on my nerve. I can imagine there's probably, I would love to know, and we mentioned this in Doug Weinstein's motion in the YSL trial. Has there ever been a study about the mental state of jurors as trials go longer and stronger? Does their mental state start to suffer and become impaired because this trial is, went from 6 weeks to now 6 months to now 9 months or something crazy like that, or even worse? I would just wonder, because it just seems like I feel sorry for jury. Even if they're back there for 10 minutes or they're back there for 10 days, I feel sorry for them, because you want to get back to your life, and you realize that this man or this woman, their lives might be in your hands. Their freedom is in your hands. But you worried about your own freedom. You worried about your own life, your own family. So I can imagine the complexity of trying to juggle that, trying to do your civic duty of being a good citizen, a good member of society, sitting on a jury and delivering a verdict. And then also, look, I got to get back to work, man. My kids, I got to pick up my kids now, that kind of stuff. So let's bring this back in, Jason. Let's go. on Monday, July 1st, 2024, at approximately 10:45 a.m., the jury sent another note to the court stating, Judge Canoni, despite our commitment to the duty of entrusted in us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds. Following receipt of that note, the court again inquired of the Commonwealth and the defendant as to whether there had been due and thorough deliberations. The Commonwealth argued that although the jury had been deliberating for approximately 22 hours, given the length of the trial and the number of witnesses, the jury had to yet engage in thorough deliberations. Attorney Yannetti again sought the Tui Rodriguez instructions, stating that the jury has come back twice, indicating essentially that they are hopelessly deadlocked. They said that they've been over all the evidence. At this time, they say they have fundamental disagreements about what the evidence means. It's a matter of opinion. It's not a matter of lack of understanding. I like it. And I say like it only in the fact that it's very clear. This one is very clear. Unlike our favorite trial here in Fulton County, there's a lot of concrete stuff. There's concrete stuff. There's a physical person that is deceased. There was physical wounds on the person. There was damage on the car, that kind of stuff like that. Sure, there was a little bit of hearsay things, but it wasn't like rooted in hearsay. It wasn't anchored in, speculation. Now, I do kind of want to dig in a little bit more, listen to some of the things that some of the attorneys said, like the woman was Google searching about how long does it take to die out in the cold and stuff like that. Like, why was she doing that? Like, what's going on? I do appreciate that, and I do want to look at a little bit more into that. But this one right here at least seems like there's concrete evidence for the people to deliberate and for them to work through and kind of parse through, rather than a lot of conjecture. But also keep in mind, the Atlanta trial is allegedly a gang enterprise trial, and this one is just a murder versus, if Karen Reed was a kingpin or something like that, it probably would be significantly different. But let's get back to it. The court found that at this point, the jury had engaged in due and thorough deliberations, noting that this has been an extraordinary jury. The court indicated that it had never seen a note like this, reporting it to be an impasse. At approximately 11 a.m. on July 1st, 2024, the jury was advised of the full Tui Rodriguez instructions, including that it was the jury's duty to decide this case if you can do so conscientiously, and that there is no reason to believe another jury would be more competent to decide this case. I think that sounds pretty straightforward. On July 1st, 2024, at approximately 2:30 p.m., the jury sent a final note to the court stating, despite our rigorous efforts, we continue to find ourselves at an impasse. So we got this impasse word again. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the element of the charges beyond reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not significantly establish the necessary elements of the charge. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. Following receipt of this note, the court discharged the jury and declared a mistrial. The representations made in counsel's affidavits have no legal bearing on the mistrial, as the jury did not reach any verdicts, partial or otherwise. A verdict must be reported in open court. The only verdict which can be received and regarded as a complete and valid verdict of the jury upon which the judgment can be rendered is an open and public verdict given in and assenting to in open court as a unanimous act of the jury and affirmed and entered of record in the presence of and under the sanction of the court. Got you. So you can't say, well, hey, we said that he's guilty back in the back deliberation room, but when we got out in the front, we got to say that. We got to commit to that in open court. And none of that happened is what they're saying. Okay, that makes sense. The verdict which determines the rights of the parties and is admitted of record and upon which judgment is rendered is the verdict received from the lips of the foreman in open court. That's why they say, I forgot how they say it, like, we the jury find John Jacob Jingleheimer Schmidt guilty. I think that's how they say it, some form of that. It is not enough to show that the jury may have agreed on some issues at some time if that limited showing were to control uncertainties would be invited. No error is the judge's refusal to accept the not guilty verdict slips found in the jury deliberation room after the jury was discharged, where those slips were in contradiction to the jury's report and the judge in the open court that they were deadlocked. Okay. So they probably did a poll. It sounds like the jury was doing a poll, like, okay, all right, slips of paper, put in what you think. And there were some people that said it was not guilty. Some clearly probably said guilty, and others probably abstained or didn't know fully. So that's why they were deadlocked. The hearsay comments and juror statements about what happened are legally irrelevant as the jury failed to reach any verdicts. So I kind of get what he's saying here, or what the Commonwealth is saying here, because at the current moment, that looks much better, matter of fact. At the current moment, because no verdict was given, it really doesn't matter what they were arguing in the debate room. It's kind of like, you got Thanksgiving dinner coming up and you and your family are arguing about what you're going to cook, but really only matters what is cooked. So what is brought to the table on Thanksgiving Day? The mac and cheese, the cranberries, the fried turkey, however you do it, all those kind of things. That's really what matters. It really doesn't matter what you were thinking about. Oh, I want to do a duck, or I was thinking about doing a brisket. Those things don't matter. It's what was actually brought to the table on the day. So I can kind of see that. The hearsay comments and juror statements about what happened are legally irrelevant. I already said that. In Blue Ford, the jury sent a note to the court indicating that they were hopelessly deadlocked. I said dreadlocked. And the court asked the foreperson to disclose the jury's votes on the 3 charges: first-degree murder, manslaughter, and negligent homicide. The foreperson reported the jury unanimously agreed the defendant was not guilty of murder, but were deadlocked on manslaughter, and they had not voted on negligent homicide. Okay, I got that. The court gave the jury an Allen instruction akin to a Tuy Rodriguez instruction that emphasized the importance of reading a verdict and instructed the jury to continue deliberations. Okay, I got that. After half an hour, the jury reported that they had not reached a verdict and a mistrial was declared. Okay. And that is in the whatever this case was, the Allen case. Okay. United States Supreme Court rebuffed the defendant's claim that the jury acquitted him of murder, as the foreperson reported was not a final verdict, because the jury had continued to deliberate and, more importantly, gave no indication that they were still unanimous on the murder charge. Okay. The United States Supreme Court emphasized that when jurors engage in discussions about the consequences of circumstances of the crime, it often causes one to rethink their stance on a greater offense and revisit a prior vote. The very object of the jury system, after all, is to secure unanimity by a comparison of views and by agreements among the jurors themselves. A single juror's change of mind is all it takes to require a jury to reconsider a greater offense. Okay, I got you. That makes sense. The Tuy Rodriguez instruction is designed to urge the jury to reach a verdict by giving more serious consideration to opposing points of view. It must be recognized as a practical matter that jury votes, bring myself back in here, sorry about that, the jury votes on including offenses may be the result of a temporary compromise in an effort to reach unanimity. A jury should not be precluded from reconsidering a previous vote on any issue, and the weight of final adjudication should not be given to any jury action that is not returned in a final verdict. Long story short, you might have 3 charges. You all might have agreed that the first charge was thrown out, but later on you might reconsider because you hear the argumentation for count 2 and count 3. You might actually change your mind about count 1 that was unanimous a moment ago. And you might want them to not throw it out. So that's how I'm understanding it. Let's see. Oral affirmation of guilt or acquittal in an open court is the only evidence that the court can receive of face and unanimous assent of the jury to the verdict. You got to read the verdict out loud and in the open. If it doesn't get read out loud and in the open, it don't happen. So y'all can be talking about it on the elevator. You can be talking around the lunch table. Of course, you're talking about it in the deliberation room. But guess what? If you don't get a verdict that you all can agree to and they read it out loud in court, let's just say it doesn't happen. It doesn't exist. The jury's notes were ambiguous, that the jurors were deeply divided by the fundamental differences of their opinions and state of mind. That resulted in a starkly divided jury. As to the charges, emphasis on plural, the jury consistently indicated that their impasse was not due to a lack of understanding of the law or the charges, but a profound divergence in a deeply held convictions, ultimately leading to a point where the consensus is unobtainable. The jury's notes did not indicate agreement or acquittal on any of the charges. Now, I think that would have been interesting if they said, I don't know, Judge, we have agreed that John Jacob Jingleheimer Schmidt is innocent of the first charge. We're still debating the second charge, but he is innocent of the first charge. And I don't know, currently we're divided 6-6 on the second charge. Something like that. I wonder what would happen if they did that. But it would still need to be like by the jury would need to read the verdict. So that would just be, I think that would be a little bit more confusing, but I don't think it would change much. Contrary to representations made by the defendant's motion and supporting affidavits, the defendant advocated for and consented to a mistrial, as she had adequate opportunities to object and instead remain silent, which removes any doubt, or rather any double jeopardy bar to retrial. Okay, got you. Since you did not protest, and they've mentioned this in the Young Thug trial, that's part of the reasons why Doug Weinstein and Brian Steele, they say, I want to preserve the record. I want to preserve the record. So they're putting out there, yeah, I protested this. Yeah, I had a problem with this. Yeah, I wasn't cool with this, because that way it's on record that this happened and allows them to always point back to that during appeal. Consent to a mistrial may be inferred from the silence where the defendant had the opportunity to object and failed to do so. All right. Where defense counsel had told judge He believed jury was at an impasse in deliberations and had no objection to judge declaring a mistrial. Such consent removed any double jeopardy bar to retrial, please forgive me. Despite having an adequate opportunity to object, the defense counsel remained silent, proper to infer their consent, their counsel's conduct, that defendant consented to the mistrial. So if you don't say anything, they're just going to assume that you agree with them. So if you don't, what is it? Speak up or forever hold your peace. It's kind of like, well, if you don't say anything, it seems like you're okay with it, whether you are or you're not. The manifest necessity test has no application in situations where, as here, the defendant requested or effectively consented to the mistrial during her full opportunities to be heard on June 28th, 2024 and July 1st, 2024. At no time did any of the defendant's three counsels request inquiry as to what charge or charges the jury was deadlocked on, whether the defendant was quick to request a Tui Rodriguez instruction at first opportunity, indicating a belief based on the clear and obvious language of the jury's notes. That, as stated by Attorney Yannetti, the jury was hopelessly deadlocked and exhausted all manners of compromise and was engaged in fundamental disagreement of what the evidence means. Its matter of opinion is not a matter of understanding, and we understand that. Counsel's request for a Tui Rodriguez instruction permits the inference that both parties were provided an opportunity to be heard on possible alternatives to a mistrial. Okay, that makes sense. The timing of a Tui Rodriguez charge is committed to the dissection of the jury judge, of the discretion of the trial judge. Once a Tui Rodriguez instruction is given, the jury could not be sent out again to continue deliberations without their consent. Furthermore, following the discharge of the jury, the court engaged the Commonwealth and defendant in discussions about choosing a status. Hold on one second. Status date for scheduling a retrial. At no time during the hearing did the defendant object or indicate displeasure with the mistrial. Okay, that's pretty bad. It doesn't sound like she was just sitting quiet. And a lot of that seems like maybe she really didn't. I don't know. I'm just reading this the first time. The mistrial was also supported by manifest necessity, jury deadlock. In considering whether to declare a mistrial over a defendant's objection, the court must give counsel a full opportunity to be heard and careful consideration to alternatives to a mistrial. A frequent and traditional example of manifest necessity to declare a mistrial is where the jury were discharged because they were unable to come to an agreement on verdict. Mistrial warrant where jury reported inability to reach decision after 4.5 hours of deliberation, during which the jury twice sent judge messages about impasse and judge inquired about jury ability to reach agreement. Okay, I wonder where they got the word impasse. I wouldn't use the word impasse naturally. I wonder if there was any kind of encouragement to use the word impasse, because it seemed like that was the right word to use to get them out of there. Describing a hung jury as a prototypical example of manifest necessity, mistrial warranted where jury reported deadlock on fourth day of deliberation after the judge inquired about the ability to reach a verdict. The trial judge is best situated to determine whether the ends of substantial justice cannot be attained without continuing the trial. Okay, got you. In declaring a mistrial, permission upon the trial judge's belief permissed upon the trial judge's belief that the jury is unable to reach a verdict. The decision to treat with great difference, because otherwise there would be danger that the judge would employ coercive means to break the apparent deadlock. Okay. And we definitely know about coercion. Deadlock juries are particularly susceptible to coercion. We can understand that. I also think juries that have been held for months upon months probably also, just my little 2 cents. The term manifest necessity is another way of saying, in a particular case, the right of the defendants must yield to the public. The rights of the defendant must yield to that of the public. Okay. A trial judge interacts directly with the jurors and is in best position to determine whether the jury is deadlocked. The court engaged in considerable efforts and sent the jury back to deliberations 2 times, following the notes that they were at an impasse, and in addition to find that the jury had engaged in due and thorough deliberations and provided to Rodriguez instruction at the request of the defendant, and that their satisfaction during the deliberations, the court amended the verdict slips to depict clearly a lesser included offenses, and provided the jury a supplemental instruction on how to consider lesser included offenses. Wow. Okay. The United States Supreme Court has never required a trial court before declaring a mistrial because of a hung jury to consider any particular means of breaking impasse, let alone to consider giving the jury new options for a verdict. Long story short, once you've directed the jury, you can't redirect them and say, well, if you can't come up with murder and manslaughter, then you can get them for jaywalking. You can't just change it up like that. That's not the case. You can't do that. The defendants claim that the judge should have inquired of the jury holds no merit, as nothing in our case law or in the code required the judge to make either inquiry whether there is a reasonable probability of a unanimous verdict or if the jury would consent to further deliberations. As a matter of course, the circumstances before the judge did not necessitate either inquiry. The final note from the foreperson unequivocally stated that the jury were unable to come to a unanimous decision. In other words, that the jury were deadlocked. The note did not suggest, for example, that the jury was merely having trouble making a decision or needed further instructions from the judge. Given the 4 days of deliberation, the jury indicated that they had clearly reviewed all of the evidence and that their divergent opinions were premised upon deeply held moral convictions. The court was left with no reasonable alternative other than to declare a mistrial. Further consultation with the counsel would not have produced any fruitful alternatives, nor was there a reasonable probability the jury would have consented to deliberate further, particularly when the jury wrote, to continue deliberate would be futile and only serve to force us to compromise these deeply held beliefs. All right, getting that down, basically, if you twist their arm, they're going to just say something, and they've already said that they strongly disagree with one another. Moreover, whether counsel indicates contact with the discharged jury by first sending notice to the opposing party with the substance of the proposed communication, or if the jury initiates contact with the counsel, as alleged in the defendant's motion, counsel by communicate with the judge only about permissible subjects. Permissible subjects include counsel performance during the trial, extenuous influence on the jury in deliberation, or the jury's bias toward the defendant. And we got that law right there. Neither extraneous influence nor a claim of juror bias is alleged by the defendant to have been the issue. Even in circumstances where juror testimony is needed to ascertain whether there is racial or ethical bias or extrajudicial influence, the judge may not inquire into the jury's subjective thought process, content of deliberations, or reasons for concluding guilt or acquittal. Rather, what the defendant's motion is entirely premised upon, and what is expressly prohibited inquiry is that the jury's deliberative process and substance of the jury's deliberations. And we know that it's Commonwealth more. The secretary of the jury deliberations has served as a bedrock of our system. An inquiry into the jury's deliberative process would intrude improperly into the jury's function. The common law principle that the essential to the freedom and independence of the jury deliberations, that their decisions in the jury room should be kept secret and inviolable, was not and arguably could not be overruled. And we know that from this case right here. Internal citations and quotation marks were omitted. It is improper for counsel to inquire with jurors or through intermediaries the individual or collective thought process of the jury, the reasons of the decision, or the substance of the deliberations. You can't go back and say, well, what did y'all talk about? Okay, that makes sense. Massachusetts continues to adhere to common law principles, barring the inquiry into the contents of jury deliberation and any impeachment of the jury verdicts based on information gained from such inappropriate inquiry. Similarly, it would be improper for the court to inquire through affidavits or an evidentiary hearing the substance of the jury's deliberations if, after communicating with the juror, an attorney wishes to secure an affidavit from the juror. Any such affidavit must force an extraneous influence. Wow. You can call them back after the fact. That's wild. And not the substance of the jury's deliberations or the individual or collective thought process of the juror in the juror or the jury as a whole. Got you. Can't call them back singularly. Can't call them back as a whole. Got you. Trial judge acted within the discretion to declare mistrial where proposed inquiry of deliberating jury could not be made without inquiring into the deliberative process of the jury. The Supreme Justice Court has instructed that whether the judge asks for individual jurors about the possibility of extraneous influence on jury deliberations, whether the jury who are still sitting as such a juror who have been discharged, the purpose of the individual voir dire is not to delve into the jury's deliberations. There should not be an inquiry into jurors' individual or jurors' collective thought process. And we know that right there. Likewise, polling the jury on the various possible verdicts during the deliberations or after the discharge will constitute an unwarranted, unwise intrusion into the providence of the jury. And the Supreme Court justice has cautioned strongly against risk of coercion, coercion inherent in questioning jurors' partiality in individual colloquies. That word is funny to me. All right, let's get done with this. It was the last, what I got, about three? Two pages, and really a paragraph. This paragraph and then the last of it. Okay, so if you're just jumping in, we just went over the Karen Reed trial. Just kind of got a high view of the Karen Reed trial. Let me jump in real quick. Big screen. So we just went over the Karen Reed trial, just kind of get an understanding of it. Now, since it was deemed a mistrial, she filed a motion to get it all thrown out. That motion was denied. So now we're reading the motion that was denied, and I'm almost finished with it. All right, let's go. One cannot assume from the mere report of deadlock that there is any final verdict lurking within that deadlock that may be extracted. In many instances, asking a deadlock jury about partial verdicts would constitute attempting to extract from the jury something that does not exist. Asking a jury to report where they stand on offense as charged invites the report that they may be based on, that may be based only preliminarily tentative deliberation, if any, on the level of offense or the hasty resumption of deliberations occurring that level of offense in an effort to satisfy the judge's apparent desire for a decision. Okay, I got that. Some inquiries of the jury may succeed in extracting a partial verdict, but we cannot have confidence that the partial verdict was the product of a thoughtful and thorough deliberation process. The risk of jury coercion are too high, and the reality, or rather reliability, of any such partial verdict returned is too low to warrant such an approach to salvaging the partial results of a deadlocked jury. So if they're deadlocked, just let them be deadlocked. Don't try to separate the dreadlocks. Don't separate the dreadlocks. Similarly, even if the deadlock does pertain to some distinction between the various levels of an offense, a judge has no way of knowing whether the jury have in fact fully considered the offense as charged. A desire to extract information from a deadlocked jury does not solve the significant problem of attempting to do so. A court's inquiry into possible verdicts inappropriately intrudes on the jury's function, and the ostensible benefit to be gained by such a procedure are outweighed by its risk. For the foregoing reason, the defendant's motion should be denied, as there was no verdict that acquitted the defendant, no grounds for the counsel to inquire into the deliberative process and discharge the jury. Yeah, because if the jury had found a verdict, they could have polled the jury. Right, got it. Discharge the jury. The defendant's consent to a mistrial and the court properly declaring a mistrial due to a deadlocked jury who was at an impasse due to their starkly divided perspectives on evidence and a sincere adherence to individual principles and moral convictions. As such, retrial is not barred by double jeopardy or constitutional principles. The Commonwealth may retry the defendant on the three indictments and any inappropriate lesser included offenses. Respectfully submitted for the Commonwealth, Michael Morrissey, District Attorney. I think we saw him in that video. I think we did see him. Morrissey, that name looks familiar. But that is, let me just real quick scan down. Yeah, this is a certificate of service. But this has been a very interesting case. And I do appreciate my subscribers who've told me about this and say, hey, Jason, you need to look into this. So I really do appreciate it because it's definitely something that has stood out. And there's lots of shenanigans going on. So I think, if I'm not mistaken, it's coming back in January or December. But needless to say, we'll probably do a recap of it, maybe check in, maybe tap in, whatever. But can't say we're going to do it all day. Hopefully the YSL trial will be over. But I can't promise you we'll do it all day. But maybe we'll just do like a recap every day or every 2 days or something like that. But thank you all so much. I appreciate all of the commentary in the chat. Thank you so much. I see my brother Nicholas has stopped through. Thank you so much. Captain Flat-tastic has shown through as well. The real Jax is in the house. Thank you so much, Real Jax, for stopping through. I see Red Jax in the building, and the Real Jax. All right, let me see. I think I got everybody. I hope I did. If I missed you, please don't count it against me. John is in the building, if I didn't already say John. Thank you so much, sir. Oh, yeah, and then Gordon. Thank you, sir. I appreciate you. Do you think Glanville took any of the stuff about judges should not be doing to set up cohesion in the case to the jury? I don't know. That's a great question, though. Yeah, I appreciate the likes, man. I do appreciate the likes. If you do like this content, my name is Jason, by the way, if you just tapped in. You're like, what this guy talking about? So my name is Jason. I do social and political commentary from a Christian male perspective. And I love talking about these cases because it's just so interesting. So right now we're looking at the Karen Reed trial. I've talked about in times past, of course, the YSL trial, the Trump interference trial, and I got the feeling there's going to be more as well. So definitely, if you like this, hit your boy up. I appreciate it. But I do want to say thank you to everybody who's been following me. This has been a very busy week. We got a lot done, but I really do appreciate it and wanted to go over. But I do want to encourage you. Hey, if you run across something you think it matters, you think it might jump out and be something I should look into, don't hesitate to drop an email, dearwokec@gmail.com. Let me drop that email in here if I can see it right here. Okay, but I do appreciate y'all so much. We got a lot to do this weekend, so hopefully you all have a restful, peaceful Saturday, beautiful Lord's Day, and we'll be back on Monday, if not sooner. Everybody, thank you so much. I'll talk to you real soon. Grace and peace.